Yes, Mr. Pickering.
My Lords, I now move on to the 3 grounds of appeal. And without wishing to create a rod for my own back, in the 1 3/4 hours which I have, I propose to spend roughly 30 minutes on ground 1, 15 minutes on ground 2, and 1 hour on ground 3, the Manchester point, which I suspect is the most demanding point. My Lord, starting then with ground 1, and this is the no loss issue, and the headline is this: because of what we describe as the immediately, necessarily, and automatically incurred expenditure, in other words, expenditures such as commissions or professional fees which would not be incurred but for the entry into the transaction, the receipt of investment monies was not balance sheet neutral, such that unlike Stanford SIB, a loss was suffered. And my Lords, we say this point is in itself without any other points and sufficient to merit the appeal to be allowed and the case to proceed to trial. My Lords, we summarise the Stanford case in our skeleton argument, our replacement skeleton argument, which is within the core bundle at page 52. Your Lordships will no doubt be familiar with the facts. They're relatively straightforward, or rather, for present purposes, they can be summarised. We summarise in paragraph 17. The claimant, SIB, was a bank in liquidation with debts of $5 billion as a result of being used as part of a Ponzi scheme. SIB had held bank accounts at HSBC. At some stage, HSBC had paid out some £116 million to certain creditors at SIB. So these were legitimate third-party creditors of SIB. Following the liquidation, SIB brought a claim alleging that by making those payments, HSBC had acted in breach of a quince care duty. It wasn't struck out at first instance. On appeal, the Court of Appeal allowed the appeal and struck out that claim, including on the basis that no loss had in fact been suffered. My Lords, we reference here paragraph 34, but it merits, if I invite the Court to look at the judgment itself, just a few paragraphs within the authorities bundle at page 182. As I think my learned friend Mr. Saul mentioned before lunch, the leading judgment was from Sir Geoffrey Voss, Master of the Rolls.
This case went to the Supreme Court. Ought we to look at what the Supreme Court said, or is the Court of Appeal good enough?
The Court of Appeal is good enough. This point was upheld on appeal. So the judgment here remains good law. The relevant part is at page 190 within the bundle.
Yep.
And we can see the subheading issue 1, was the judge right to allow the loss claim to continue? Paragraph 29, it's important to understand the start claim that SIB, that's in liquidation, makes in the context of HSBC's argument that the loss claim should be struck out. SIB's sole claim is to the £118 million that it says would not have been paid out of the accounts after a particular date had HSBC performed its quince care duty to SIB. It's of course plausible to imagine consequential losses that SIB might have sustained, but no such losses form the subject of this issue. And 30, SIB does not claim that its net worth was less overall as at the 17th of February, when it did freeze SIB's accounts, than it was at the 1st of August 2008, when SIB says that HSBC ought to freeze accounts. It seems that a company operating a Ponzi scheme would be likely to have greater debts as time progressed, but SIB disavows such an approach. The question then is simply whether SIB suffered a loss as a result of paying a maximum of some £116 million between certain dates to the holders of the deposits, of which some 36 million went via SIB's own account at TDB. It might be thought to be obvious that SIB cannot have sustained a loss by paying itself £36 million. HSBC says it is equally obvious that SIB cannot sustain a loss by paying its creditors, and thereby reducing its indebtedness pound for pound. SIB argues, however, and the judge held, that SIB's state of insolvency makes all the difference because in effect cash is crucial to SIB, and it would have had at least £80 million more in cash as at a certain date if HSBC had putatively performed its duty. It would then have been able to pay other creditors more once its insolvency process began. In my judgment, the problem with this argument is that HSBC did not owe any duty to SIB's creditors. SIB's directors owed a duty to its creditors as soon as it became insolvent. Reference is made to West Mercia. 33. Even though SIB's directors owed a duty to SIB's creditors during the period in question, HSBC did not. Its duty was to SIB alone, as explained in Singularis. See paragraph 81, where it was recorded that it had been agreed that Quince-Care duty was owed to Singularis. 34. The point here is that SIB itself did not lose anything as a result of the payment of £116 million to discharge creditors and to another account in its own name. Its net asset position at the end of the period was the same as at the beginning. My lords, if I can return to our skeleton argument in the core bundle on page 52, we summarise our position in paragraph 18. In short, therefore, before the transaction in question, SIB had had certain cash held by HSBC and certain liabilities as creditors, and therefore had an overall net worth.
It didn't have an overall net worth. It was heavily insolvent. It had nil worth throughout the period. I mean, that was one of the problems, is that if HSBC had pulled the plug earlier, it wouldn't have had any positive net assets, and that was true when it pulled the plug later. So,
my lords, what do we mean by net at the balance sheet position? Well, in terms of net value, your lordship is of course right, it had zero value, but its balance sheet position, it had a certain deficiency.
Yes.
Net deficiency, and at the end of the day, its net deficiency was the same. And my lord, your lordship is absolutely right in terms of worth, but in terms of our second sentence, after the transaction, it had less cash, which HSBC had paid away, but its liabilities had been reduced by an equivalent sum. That sum had been paid to creditors, legitimate creditors. So its overall net, my lord, deficiency was the same. So on a balance sheet basis, it had suffered no loss. Now, my lord, this was the case which, my lord, from Mr. Saul referred to the judge, and our submission was and remains that on the particular facts of its case, we don't suggest that was wrong. But what we did submit, and we do submit now on this appeal, is that those facts are very different to the facts of the present case. And my lord, in broad terms, the claimant's case is this: if Lupton Fawcett had complied with its duties, and my lords, I repeat this because it's important to remember, many of the cases to which reference is made in the Manchester case and elsewhere are appeals after a trial. This, with the exception of Saddington, is an appeal following a strikeout or summary judgment. So for these purposes, we invite the court to, in the usual way, to assume the pleaded case would be proved at trial. So in broad terms, the claimant's case is this: if Lupton Fawcett had complied with its duties, the claimants would have been advised of three key matters. First, they would have been advised that they were operating unauthorised CIS, or that there was a real risk that they were still operating unauthorised CIS.
Yep.
Second, they would have been advised that if they did so act as an authorised CAS, they would then become immediately liable under section 26. And that's A, to repay any monies received, and B, compensation. And as a result, the third point, they should have been advised, at the very least, not to accept any or any further investment monies. In terms of the scope of their duties, my lords, I'll come back to that in the pleadings a bit later. What the claimants further say is that if so advised, the SPVs would not, indeed could not, have entered into any transaction with investors. In other words, they would not and could not have accepted any further monies. And this is the factual causation point, which the judge accepted was credible, had a sufficient prospect of success. In fact, however, Lupton Fawcett did not give that advice, and as a result, the claimants continued to accept investor monies over a period of several years, which, because they were unauthorised, they immediately became liable to repay under section 26.
When do you say the advice should first have been given?
My lord, we say, in terms of NPD, from the inception, we say that because the Green advice,
Yep.
the advice of Mr. Green, predated.
So the inception's what, April 2016?
My lord, 2018. So 2016. 2016.
And anything before that would be statute barred anyway.
Lord, yes.
Yep.
So as to the loss which the claimant say has been caused by this negligence, and we're not considering the scope of duty, we're just considering actual loss. The starting point is the difference between, on the one hand, the position the SPVs would have been if properly advised. On the other hand, its actual position. If properly advised, quite simply, the claimants would not and could not have received any further investment monies. So our primary position is from inception, so it couldn't have received any monies. We have later dates in our pleading. And if that, but only that is proved, it'll be from those dates.
Is the could not point based entirely on section 26?
My lord, it's based on the practical realities, is that we don't suggest that Mr. Woodhouse had any particular scruples, but the FCA were closely monitoring, and they relied on advice from Lupton Fawcett, and investors would often be seeking advice. If Lupton Fawcett had given firm advice earlier of the particular implications, Mr. Woodhouse and the SPV simply could not have,
In practical terms.
In practical terms.
And as pleaded because of section 26.
My lord, yes.
Thank you.
Well, I mean, I don't think it's a matter for today, but it's striking when you took us through your pleading that Mr. Green did give very firm advice right at the outset, admittedly to MBI rather than NPD. Mr. Woodhouse appears to have just ignored it.
My lord, yes, but that's qualified because we then see the discussion with counsel and Lupton Fawcett, and then there's the letter which I haven't taken, your lordships, which Lupton Fawcett write to the FCA, which gives them breathing space. And then they obtain the advice from Professor McGee. Mr. McGee gives green light advice, although Professor McGee wasn't given the detailed instructions, the underlying documents. So, my lord, what we say is that they didn't like the green advice. They instead found Professor McGee. They didn't tell Professor McGee of Mr. Green's advice. They didn't give Professor McGee the underlying documents. And with Professor McGee's various advices, they were able to continue operations. So, my lords, we do not suggest, I repeat, that Mr. Woodhouse would have stopped because of scruples or any desire to be compliant, but had Lupton Fawcett carried out their job properly, the operation simply could not have continued. The FCA would have intervened, and investors wouldn't have invested. They had to have gone to different solicitors, but other solicitors, one has to assume, would similarly have given non-negligent advice and said this is an unauthorised CIS. So the scheme would not have been able to continue.
Okay.
So, my lord, if properly advised, the SPVs could not have taken any money from whenever the advice should have been given, which we say our primary cases from inception. The actual, and therefore it would be a neutral position. It would have received no monies and would have had no liabilities arising out of those investment monies. In fact, because of the negligent advice, what was advised and what was not advised, the SPVs were able to and did receive investment money, some £68 million investment monies.
Well, that's not a loss.
Lord, well, Lord, I'll come on to that. That's the scope of duty point.
No, we're on the loss point. The counterfactual is the schemes stop, no money comes in, no Section 26 liability. The actual is 68 million comes in. I've just said, stopping there, that's not a loss. That's
Yes.
the companies are 68 million better off.
Yes.
But they have a corresponding liability under Section 26, so they're 68 million worse off than in the counterfactual. The judge's point, as I understand it, is getting 68 million in and having immediately to repay it, assuming you're right about that, is neither a loss nor a gain. It just leaves you in a neutral position.
Lord,
That's the point you have to meet on appeal, I think.
well, Lord, yes, and we do, and we meet that
Yeah.
face on. Because in terms of that analysis, in fact, I put this to Mr. Justice Sheldon in those terms. We would accept that. And I'd invite the court to go to our skeleton argument at it's page 54.
Yep.
And
It's paragraph 25.1.
my lord, yes, and we set out a couple of hypothetical examples of £100,000. And point one is exactly your lordship's point. If following receipt of the £100,000, the relevant SPV had simply kept 100% of that money in the bank account, no loss would have been suffered. While it would have incurred an immediate liability under Section 26 to repay £100,000, it would have gained the same. Result is no loss. And I'm leaving aside the compensation point for now. The second point, which is the SIB point, if following receipt of the £100,000, the SPV had used that money to discharge pre-existing liabilities, what happened in SIB, again, no loss would have been suffered. While it would have incurred an immediate liability under Section 26 to repay, it would have enjoyed a decrease in its liabilities in the same value. So the overall effect would be balance sheet neutral. So, my lord, we accept that, and we've never said otherwise. But what we say in 26, in the present case, neither scenario happened. The investment monies received did not just sit in SPV's bank account, nor were they used to discharge pre-existing liabilities. And they were applied in broad terms to pay. And there are 2 points here, and I'm dealing presently with number 1, the immediately, necessarily, and automatically incurred expenditure.
What do you mean by automatic?
Well, my lord, commission, for example, and in fact we set this out in paragraph 27. The commissions, and I can refer to them in the original current pleading, are to various sales agents. If the transaction didn't go through, no commissions were payable. So in broad terms, it's not the case as in SIB, where if £100,000 is used to pay off a pre-existing liability, it has less cash, but it has a decreased deficiency. If, for example, there's a 12.5% commission, if £100,000 is received, automatically on the making of the investment, there is a liability of, for example, 12.5%. And the examples of these we set out in paragraph 27. These included, and there's evidence, I'll take a look at the evidence in a moment. These included, but not limited to, commissions which were payable for the investment monies to sales agents, which arranged the investments which were payable only in the event of an investment being made. That's what we mean by automatic. The SPV's own legal and professional costs, which again were payable only in the event of investment being made, and the investor's legal and professional costs. And we say 28, according to the making of an investment of £100,000 into the NPV schemes, by the very making of that investment, the net money actually received by the SPV was significantly less than £100,000. And my Lord, in terms of the evidence, before Mr. Justice Sheldon, there were various witness statements, including in the supplemental bundle at page 65. We have a witness statement from Mr. Dunnell of my instructing solicitors. The relevant part at page 65 is paragraph 34.1, and in short, in the statement in support is Mr. Reed of my learned friends instructing solicitors, and this is effectively an argument in response, but it sets out some evidence. Mr. Reed states that immediately after entry by the SPV into an agreement with an investor, the SPV has received a sum of money for the investor, say £100,000, and the investor has the entitlement under section 26 to demand the return of that sum. This is of itself an accurate statement. However, Mr. Reed's statement ignores the obvious fact that the investor's money was not paid across the SPV for it to simply hold pending payment of section 26 liabilities. Rather, it was paid across for the purpose of funding the scheme in which the investment was made, which comprised inherently illiquid investments in loss-making property development schemes. The investors' monies were paid to fund the investment schemes of the SPV into which those monies were raised. Those investment schemes all had long-term liabilities. They comprised assets which were liquid and which clearly would only be in a position to fund investment or repayment liabilities after the construction or refurbishment of the relevant property and the development of the underlying business to be carried on to the property to substantial profitability. Initial deductions of up to 52.5% were made for the amounts received from investors in respect of developers' deferred investments, agents' fees, investors' returns of 10% had to be refunded. These
What
costs,
are developers' deferred investments?
my Lord, possibly a red herring, but I'll explain how they work. If an investor agreed to invest, for example, £100,000, they would in fact put forward £60,000 of cash. They'd be credited with £100,000, but they owe £40,000. Each year, if they're offered a return of 10%, say £10,000, if they've paid in full, they would get their £10,000. But if they've deferred, so they've only paid 60, for the first, in the example, 4 years, the £10,000 would simply go towards reducing their deferred consideration.
How much, in such a case, would the section 26 liability be?
The £60,000.
Yes. So if they pay 60,000, what they get under section 26 is they get 60,000 back.
My Lord, yes, which is why I say it's a red herring and we don't rely on it for this no loss argument.
But that 52.5%, if 40% of that is made up of developers' deferred investments, which is what this suggests, then it's a much less striking figure.
My Lord, yes, the sales agents' commissions, they varied, but were generally in the order of 12.5%. We plead that in the statements of case. And there are also the legal costs, which are small, relatively small. The figures are in the schedules.
Okay.
It's roughly, top of my head, and the figures are there. It's some £7 million of agents' fees or commissions, and roughly £700,000 of solicitors' fees. The figures are in the bundle. Well, the short point here is that on the making an investment of £100,000 into the schemes, by the very making of the investments, the net money actually received was less than £100,000. So to give a hypothetical example, if the court were to imagine a hypothetical investor of £100,000 who wishes to invest, the investor pays that £100,000, so there's no deferred consideration in this example. The investor pays £100,000 to the SPV solicitor in anticipation of the investment. The investment still hasn't taken place. The green light is then given. The solicitor then uses the money to pay the various commissions and agency fees and professional fees, which become immediately payable on completion. And then they pay the net balance to the SPV. So what goes into the SPV bank account is not £100,000 pounds, but a figure less than that, substantially less than that.
About 86%, about 86,000.
We don't have the precise figures, but it may be along those lines.
I thought you said 12.5% for agents' fees on average, and roughly 10% of that for solicitors' costs.
Well, yes. In broad terms, if one focuses on those two, yes.
Right. Okay. What is wrong with the argument that is put forward against you when the 100,000 is, on your example, received by the solicitors? It's all the SPV's money. It's paid to the SPV. It's paid to the solicitor as agent for the SPV. The SPV then spends some of it on things it's committed itself to. What's any different about that from spending money on other things that the recipient is committed to?
Well, we say there's a fundamental difference. If it was paying off pre-existing liabilities, that it's like SIB. It's actually robbing Peter to pay Paul. It stays in the same balance sheet position. But for the £100,000 is paid to the solicitor in anticipation, and your lordship is right, it's agent on behalf. But at that moment, there is no liability to pay, for example, the sales agent fees or the legal costs. It's only on entering into the investment that those liabilities accrue. And so, for example, in the example I gave, if £100,000 is paid whether directly or via the solicitors, it's when the investment is accepted. In fact, a lesser sum, whether it's £86,000 or whatever, is what actually the SPV receives. But for the investment, it wouldn't have those liabilities. That's what we mean by immediately, automatically, necessarily incurred. So we're not talking about other commitments which it already has or may have in the future. I'll come on to those in a moment. We're talking about expenditure which necessarily arise out of the very transaction itself.
Well, it's only necessarily arising out of a transaction because the SPV has already entered into obligations with its solicitors and its agents to pay them fees and commissions in the event of a successful investment.
Well, yes, but if it doesn't accept any money, it doesn't owe any commission. So, my Lord, let's assume the solicitors accept £100,000 and they say, actually, we're not going ahead with the deal. No sums are due to the agents. So, my Lord, it's different from SIB. We accept entirely that paying off pre-existing liabilities is balance sheet neutral. But paying off liabilities which arise solely out of the transaction itself, it means that £100,000 is the liability arises for £100,000, but in fact it only receives net some £86,000 on, or whatever the sum is.
Yeah.
Well,
Okay.
we say that's the first point. It's a shortish point, but we said the judge's analysis to say that there was the pound in, pound out approach SIB applies is wrong. So we say it's absolutely distinguishable on that basis.
Can I see if I followed this, please? Your skeleton helps set out your argument very clearly and helpfully. you took us to paragraph 25. You've got two examples there. You accept those two examples are balance sheet neutral.
Well, yes.
That's in a situation where the inflow of 100,000 is balanced by what you describe as the immediate liability to repay that sum under section 26. Have I understood?
Well, yes.
When we turn over the page to page 8 of your skeleton, I think you're suggesting we end up with a negative situation rather than a neutral situation.
Lord, yes.
But that's on the assumption that the section 26 liability is immediate. That assumption that you had on page 7 is essential to your argument on page 8, correct?
Lord, yes.
Yeah. Well, that begs the question, is it an immediate liability? And I ask this simple question. What if you have a scheme like this, which is regulated, is a CIS scheme, should have been run by authorised people, but there's no Ponzi fraud? Why is that an immediate liability? Because the investors may be perfectly happy to receive their 10% and their 12%. It would only be if the company becomes, it's only because the company becomes illiquid later on that then the liability arises under section 26. I don't, for the moment, understand why it's immediate. And then built, lastly, before I shut up, built into that is the point you were making earlier this morning about it being dependent upon an election on the part of the investor.
Well, Lord, I think the answer to that lies in section 26 itself. And if I can go back to that, it starts at, I think it's within the authorities bundle at around page 4. Section 19 is at page 4. Section 26. And in short, my lords, I'm going to take your lordships to 26 and to 28. And the broad submission is that it's, whereas there is an election and an investor can choose to enforce, it's different to the sort of election, as I mentioned this morning, where a successful claimant has a choice, for example, account or damages. Sometimes a claimant, after a trial, will have a choice to elect between either an account or equitable compensation or damages. And until he or she does so, it's at large. That's not the case here. 26 says...
By at large, you mean?
Sometimes a successful claimant will win a trial, and then we put to his or her election as to whether they go for an account of profits or equitable compensation or damages. And until he or she makes that election, then it's
unknown.
It's unknown because it's in the hands of the successful claimant in this part.
My example that I put to you is if you have a structure like this, but with no Ponzi scheme going on, the people who invest £100,000 may be perfectly happy to leave the money there while they collect their 10 to 12%. What makes the difference on the face of it here is it's a Ponzi scheme.
Well, Lord, with respect, the Ponzi scheme for this argument is largely irrelevant, and perhaps I can take your lordship to section 26 and why I say it's different, it's not at large here. Section 26, subparagraph 1 says an agreement made by a person in the course of carrying on a regulated activity in contravention of the general prohibition in section 19 is unenforced against the other party, and the other party is entitled to recover money or other property paid or transferred and compensation. So that's the automatic, we say, default position. If
you're drawing up a balance sheet, would you be entitled to put down on the balance sheet as an accountant this liability as an immediate liability?
My lord, yes.
When it might not actually crystallise.
My lord, unless and until there's an election to the contrary, section 26 bites. So if one can imagine a benign, unauthorised CIS, So it's a collective investment scheme. It's unauthorised, therefore it's not compliant with FSMA, but it's not a Ponzi scheme. In that situation, the investment company is immediately liable under Section 26(2). It's unenforceable under Section 26(1), and there's an immediate right under Section 26(2) to those two things: repayment of the money and compensation. However,
but do you not have to choose it? I'm looking at Section 28(7). So it's quite clear from 26(1) that this doesn't. So Section 26(1) doesn't declare the contract void.
No.
So it's not avoided for all purposes. It's unenforceable against the retail client, the investor.
well, yes.
It's implicit in that it remains enforceable by the investor against the unauthorised investment provider if the investor so chooses. And that is reinforced by Section 28(7), which sets out, as you showed us this morning, that if the person against whom the agreement is unenforceable, the investor, elects not to perform, so the very word elect is there, then they have to give credit for any benefits received. Now that suggests that what the draftsman of this legislation is contemplating is that Section 26 and 28 together give the investor a choice. The investment house can't enforce the contract against him, but he can continue with the investment if he wants to. He can perform it and get the benefit of it if he wants to, but he doesn't have to. He can choose not to perform it and claim the money back under Section 26(2), but in that case he has to give credit for any benefits he's received. And some investors might think, particularly the early ones who get paid out their 10%, might think they're better off sticking with what they've got than trying to unwind the transaction and giving the money back. So why is my lord not right that you refer to it as an immediate liability? It seems to me it's more accurate to say you immediately come under a contingent liability to repay if the investor so chooses.
Well, I respectfully take issue with that on the language of Section 28. And this refers back to my previous submission, in contrast to some elections where until election is made, the position's at large. So it would be a contingent position. Here, we say, your lordships have seen Section 26 and Section 28, subsection 3, if the court is satisfied that it's just and equitable in the circumstances of the case, it may allow the agreement to be enforced.
Well, that presumably means to be enforced against the investor, despite the fact it's prima facie unenforceable.
My lord, yes. And then 27, if the person against whom the agreement is unenforceable, i.e. the investor, elects not to perform the agreement, or as a result of this section recovers money paid, he must repay any money. So, my lord, that's the if. So, my lord, implicit in that is if he or she does not elect, unless and until an election to the contrary is made, the position is, as per Section 26, is unenforceable. So, Lord, this is what I meant by, yes, it's an election.
It's unenforceable against the investor.
Against the investor.
It operates one way, that provision.
So in terms of the liabilities of the SPV, the automatic position is if it receives £100,000 and it's an unauthorised CIS, and let's assume it's not a Ponzi scheme, there's an immediate liability under Section 26(2) (2)A. Now, it's possible that in due course the investor, for good reason, chooses to elect under Section 28(7), or choose an election under one provision or the other. But unless and until he or she does so, it's unenforceable. That's what Section 26(1) says.
But the language used by Parliament in subsection 2 is the other party is entitled to recover. What seems to be going on there is that Parliament is conferring a right.
My lord, yes. But it's,
So there is a liability, but that is if the right is exercised.
my lord, yes, that must be right. My lord, perhaps I can turn that. But my lord, in terms of the SPV's balance sheet,
Because, I mean, forgive me, absent that provision, the mere fact that you've got a CIS and that the operator is not authorised wouldn't give rise to such a right. In the event of a Ponzi scheme, there'd be claims in fraud and so on and so forth. But this is a statutory remedy, and it confers a right in those circumstances, which someone can choose to exercise or not.
my lord, the way we submit that section 26 has to be read, particularly the wording in section 26, not just 26 2, so it's 1, which says it is unenforceable.
Yeah, but that's dealing with the position on the part of the operator, the non-authorised operator.
Well, yes, and the claimants in this case are the operators in liquidation. And those operators,
They can't enforce it, but the investor can. So, for example, if the operator doesn't pay the 10% and you haven't got a Ponzi scheme, rather than electing to get the money back, the investor can say, I sue you for my 10%.
my lord, yes.
Well, let's test it. If I've understood it correctly, some at any rate of these investments were on terms. You pay me £100,000. I'm going to pay you 10,000 a year. And at the end of a certain period, I think it may have been 10 years, you can put the sublease back onto me, and I will pay you £125,000.
Lord, yes.
Now, suppose an investor who invested in 2016 is now asked, what is your claim against the company? And they're given advice and they're told, well, you have 3 possible claims. You've got a Section 26 claim, and you get your £100,000 back, and any compensation for any loss for having paid it over. Alternatively, you could sue for damages for deceit, and again, you'd get your £100,000 back. That's because that's the prima facie measure of damages for deceit. Or you can enforce the contract under which you'd get not only the 100,000, but you get 10,000 a year for 10 years. That's another 100,000 plus a 25,000 uplift, which is 225,000. They're also told, because these are heavily insolvent liquidations, you're only going to get 1p in the pound anyway. You'd still put a proof in for 225,000 rather than 100,000, wouldn't you?
Lord, yes, one can readily imagine a situation where an investor would choose not to rely on their Section 26 entitlement and instead to enforce the agreement.
Yes, so why in those, given that that's the case, in what sense is it true to say that the company, the SPV, became under an immediate liability in 2016 to repay the 100,000? It came under a contingent liability to repay the 100,000 if the investor so chose, which seems to me to be different. Well, I misunderstood the way it works.
Well, it's only in that final stage in our submission. The starting, as I submitted earlier, it's not as if the alternatives for the investor are, as your lordship has said, but they're not at large until he or she elects. Section 26(2) sets out the prima facie position.
Okay. I don't want to take up more of your time than necessary. I think I understand the way in which you put it. Section 26(2) sets up a default position which applies unless and until the investor elects otherwise.
Well, Lord, yes.
Yes.
And so the short point is on this first point, which it doesn't apply to all of the way the money is spent, but we say that the judge's reliance on SIB was misplaced in that this is not expenditure on pre-existing liabilities, but it arises out of liabilities which only came about necessarily and automatically because of the investment itself. So in other words, if £100,000 was received, it wasn't a pound in, pound out, because monies were spent which would not otherwise have been spent.
Okay.
My Lord, I then move on to the compensation point. This is in fact, our third ground of appeal, but it makes it's logical, I suspect, to deal with this next. We've already looked at sections 26 and 28. So what we can see is that an investor, if they do choose to go down the section 26 route and seek their money back, which we say is the default position unless he or she elects otherwise, they're entitled not only to the return of their money, but also to compensation. Now, my lords, there is no guidance in particular as to what compensation would be, and ultimately we say it will be a matter for evidence and argument. My lords, there are some obvious ways that a court may approach that, or the party may approach it. One would be to apply interest. Another would be to look at what the investor would have done with their money. So, for example, if someone invested £100,000 in a particular scheme and it turned out that it was unauthorised, they get their money back X years later, but they would have invested it in a different way. If they can show that, they would be entitled to compensation. It doesn't really matter for present purposes. The point is that it's not, again, it demonstrates it's not balance sheet neutral. The judge, again, we say, was wrong to find that the £100,000, because of the compensation, is balance sheet neutral. Not only are there these immediately incurred expenditure, but there's liability to pay back more than the money itself in terms of the compensation. So again, the judge decided to strike out on the basis that there was simply no loss. We say because of the compensation, that can't be right. My lord,
You have to make provision in your accounts for contingent liabilities in the event that people were to claim compensation.
my lord, yes.
So that wouldn't necessarily be balance sheet neutral.
My lord, yes. That's the short point. The judge held that if £100,000 came in, while there was a Section 26 liability, it was cancelled out by the cash coming in. We say that as well as our first point in terms of the immediately incurred expenditure, the liability was to repay the full sum plus compensation, question, whatever it is. And that's a question which is hard to determine at this stage. Well, in terms of how we plead that, can I refer your lordships? It's probably simplest if I refer to APOC 5, which is the version which was for the judge.
Yes.
Page 160. This morning, I think reference was made to a couple of provisions, that there are a couple more. In paragraph 66, in fact, it's part of the original current text, paragraph 66, the claimants seek declarations that the schemes with CIS were operated in breach of the Section 19 prohibition, and the claimants are liable to the investor creditors for operation of Section 26. Further, to the extent necessary, the claimants will seek indemnity from the defendants for such losses that arise by operation of Section 26. Now, my lord, it refers to Section 26, and 26 refers to A, money coming back, and B, compensation. At this stage, your lordships have not admitted the evidence of Mr. Armstrong, but what Mr. Armstrong says, we ask the court to take judicial notice the way that insolvencies work, and that monies and claims will be made. Adjudication upon those claims is unlikely to take place until monies come in. Proof of debt will be at a later stage, and compensation will have to be claimed and considered and ultimately adjudicated upon. And there are various different ways that could be. Now, what we anticipate here is that the adjudication process on compensation, or indeed the claims themselves, may post-date determination of liability. Hence, the expression used in 66 was, to the extent necessary, the claimant will seek indemnities. My Lord, that's repeated in page 224. That's section 177, which the court was referred to this morning. It's again repeated at page 260 in similar terms, paragraph 241, and finally in the prayer for relief at page 271. So if we accept entirely that in this version of the draft, we didn't spell out compensation, which in...
Sorry, where do I find it on 260? Was it 260 you said?
266, my lord.
266, I'm sorry.
It's 241. It's immaterially identical.
Isn't that from Metis?
That's from Metis.
Are we concerned with claims against Metis?
Lord, not today.
No.
But 66 was a general application, 177 relates to Lupton Fawcett, and 271.
You said that was the prayer for relief.
That's the prayer for relief indemnities as a result of the operation of section 26.
Where do you plead the operation of 26?
My lord, I'm going back to paragraph 66 at page 160. The claimant seeks declarations that the schemes with CIS operated in breach of the section 19 general prohibition, and the claimants are liable to the investors' creditors of operation of section
Yes,
20.
but if you look earlier in your pleading at page 159, paragraph 62 tells us what you plead the operation of section 26 is. And you plead two things. The agreements became unenforceable and the investors became entitled to recover their investments. Why do you not read the declarations you seek in 66 by reference to what you've pleaded the consequence of section 26 is, which is that set out in paragraph 62?
Lord,
I mean, we know now, because of APOC 6 and all the arguments we've had, that section 26 has two limbs. It has a right to recover your money and a right to compensation for loss. We are focused on what you've pleaded in this pleading, which you have to read without any reference to external matters. Just read it. When one says, I'm entitled to X, and I claim a declaration I'm entitled to X, the declaration you're claiming would normally be read as referring to what you've said you're entitled to. And what you've said at paragraph 62 is the operation of section 26 makes the agreements unenforceable and it entitles the investors to recover their investments. There's no word there about compensation under 26(2)(b), and I don't think the words compensation under section 26(2)(b) appear in this pleading.
correct.
That is the point the judge made when we were shown it by Mr. O'Doherty this morning. At the moment, I can see why the judge took that view.
Well, Lord, yes, the pleading is not ideal in that it doesn't expressly refer to section 26(2)(b). But Lord, what we do say is it doesn't expressly refer to section 26(2)(a), save that in the paragraph 62, which your Lordship mentioned, does highlight that. But my Lord, what we say, that the use of the word indemnity, rhetorically, to what else can it refer? That's why, if, for example, it's paragraph 177, which is at page 224, there are two sentences. Further, in the alternative, the claimants seek declarations that the schemes of CIS operate in breach of section 19, and the claimants are liable to the investor creditors for operation of section 26. Now, my Lord, if we stopped there, I'd accept the position be more difficult than it is, because that clearly is a reference to that could be seen to be a reference to section 26(2)(a). It says further, to the extent necessary, the claimants will seek indemnities from LF for such losses that arise from operation of section 26. So, my lord, it's not as clear as it should be, which is why APOC 6 was put in to clarify the position. But it does refer to section 26 twice, including indemnity.
Okay. Thank you.
Well, the short point again under this head, compensation, is quite simply that the pound in, pound out analysis can't be right, because if to the extent that the judge said that if £100 came in, it offset the £100 liability, whereas if £100 came in under section 26, the liability is the £100 plus compensation, whatever it is. So combined, we say rounds 1 and 3 mean that the judge's findings that this is a no loss case aren't correct.
Let's leave ground 1 on one side for a moment. Suppose you're right on ground 3. Do you accept that it means you've had 68 million in, you have to pay 68 million out, plus compensation, so your claim is limited to the 26(2)(b) payments?
My lord, no.
No, why not? That's what I'm having difficulty with. If it was just 68 million in and 68 million out, you accept there'd be no loss. You say under ground 3, there's 68 million in, there's 68 million out plus compensation. Why is your loss not limited to the compensation? This is just on ground, leaving aside ground 1's a different point, but leaving aside ground 1.
Well, this is where we want onto the scope of duty point. This is the scope of duties. The short point I'm making ground and this ground is purely on the compensation.
Yes.
Is that it can't be a pound in, pound out type situation.
I see the argument to that effect. Suppose you had one investor who had put 68 million in. He comes along and says, I want my 68 million back. And if I hadn't put it in your scheme, I would have put it in the bank and I would have had 5% interest for the last 10 years. So I want another 34 million by way of interest. Your claim would be for 34 million, wouldn't it?
My lord, it wouldn't be limited to that. That's just a compensation.
Yes, but what else? What other claim is there under this head? You've had the investment in, you have to give the investment back. That doesn't cause you any loss. What you say causes you loss is you also have to pay compensation. So why is your loss not limited to the compensation you have to pay?
Well, that's the final limb of our appeal. That's ground 2 in the scope of duty.
Scope of duty is not an extra argument for recovering money. It's an extra reason why you can't recover money. You have to show you have a triable issue, an arguable case. You've suffered loss. And I understand your ground 1 point, but on this ground 3 point, so far, I'm not persuaded that it enables you to recover anything other than any sums properly recoverable under section 26(2)(b). And you say it does. And
under section 26(2)(b), we simply say that that's another reason why the no loss argument applies.
Okay.
But in isolation, if it was nothing else.
But it only applies insofar as it produces a different situation as compared with the situation under ground 1.
My lord, yes. And
net difference.
Perhaps at cross purposes. If the simple facts were as per a straightforward case where the scheme is different than the current scheme, then your lordship, well, I would accept what your lordship says.
Right.
It's on the facts of this particular scheme. So this particular part of our argument relates, your lordship is right, only to the compensatory element.
Okay. Right. Thank you. You want to go on to ground 2, I think.
My lord, yes.
Scope of loss.
This is the scope of duty.
Scope of duty, yes.
My lord, the short point is there were the 2 headlines here. The first is that the court was clearly and obviously wrong to rely on Saddington The present case we say is a million miles away from that case. It's simply not comparable. And the second part, the other side of the same coin, is that the court should have focused on Manchester Building Society.
Okay.
And if it had, the answer we say would have become clear. Well, to give this some context, in relation to any particular investment of say £100,000, it's our case, as you'll to know, that a large portion has gone on sales commissions and legal expenses. But then, what about the balance? And this goes to the heart of matters. As to this, we invite the court to look at our skeleton at page 56 in the core bundle, paragraph 30. My Lord, paragraph 30, the schemes are always intended to make a profit, but only in the medium to long term, as evidenced by, amongst other things, the prospectuses and the terms of the schemes themselves. And Lupton Fawcett was, of course, very familiar with all of this, having drafted and prepared the relevant scheme documentation. Lord, I don't think it's in the bundles before the court now, but Mr. Justice Sheldon was shown a prospectus or two, which said that the schemes were expected to become profitable after between 5 to 7 years. So this goes back to one can imagine the scenario of a benign, unauthorised CIS. So it's a collective investment scheme, and for whatever reason, it's not a Ponzi scheme, for whatever reason, it's not authorised. But this particular scheme, this is not uncommon, we would suggest. It has upfront costs, and we see under 31, reference was made to the evidence earlier on. It acquires long-term illiquid assets, which did not result in a pound-for-pound return. So, my Lord, the pure contractual position is that an investor invests a sum of money, £100,000, and in year 2, for example, the value of their investment is going to be worth substantially less, and it's not expected, according to the prospectus, to become profitable until 5 to 7 years. That's something which is not uncommon in many schemes. Now, Lord, what we say in paragraph 32, if this
does rather prompt the question where people thought that 10% was going to come from if it wasn't making a profit.
Lord, yes.
Anyway, that's by the by.
Lord, it is. And your Lordship will recall that Lupton Fawcett prepared much of the scheme documentation and certainly...
Well, I see you say that in paragraph 30. I don't think we've actually been shown your pleading to that effect. What we've been shown is pleading to the effect that you, Lupton Fawcett, were asked specifically whether it was a CIS. Shown documentation. I don't think we've seen a pleading that they prepared the documentation.
Well, my Lord, in some of the extracts, and it was a complete canter, you'll see that there were attempts to change the scheme documentation. Advice was sought, and variations were made.
Mr. Green said, well, you should do this and you should do that.
Mr. Green said you should do this and do that. And then Mr. Asserson...
Professor Green, yes.
No, it was Mr. Green.
Mr. Green
said you should do this and that. It was Professor
McGee,
who, grateful, my Lord, who gave the green light. And Mr. Asserson had grave concerns, and there were various attempts through Lupton Fawcett to revise the scheme wording. But also, I think it goes back further to the Professor Green, sorry, the Mr. Green days as well. So it's right from the start. So, my Lord, the short point is that it was known by Lupton Fawcett that for the first few years after an investment, if an investor invested, say, £100,000, his or her investment would inevitably be worth less than the amount of the investment.
I'm sorry, I'm not following this, and I apologise. Isn't that looking at what's happening to the £100,000 in the hands of the SPV? I mean, so far as the investor's concerned, they've got a contract, they've parted with 100,000, but they're getting 10,000 a year.
My lord, yes.
So why is the value of that investment less? Because the company isn't earning returns to fund the £10,000 a year in the early years. I'm sorry, I'm just not following that.
So, for example, from investors' perspective, after year one, they would be entitled to £10,000, and they would have.
If there was no
lease.
if there was no Ponzi scheme, it's quite a valuable investment.
Well, my lord, it's
You're contractually entitled to that rate of return and get 125% after 10 years.
but the value is in this 10-year sublease, and the return which it gives. So the income, that's contractually entitled, but in terms of the underlying value of the sublease, that depends on the development being successful. So if you have a sublease which promises £10,000 a year, yes, that rental income is clear. But the value of the sublease which they also have will depend on the underlying success of the project. If they have a 10-year sublease in a project which is hugely successful, that's a highly valuable.
I thought there was a lease back also to
There's a lease back
the
option.
SPV.
Well, after 10 years, generally, there's a lease back option.
No, it's a lease back during the continuation of the investment.
Well, Lord, yes.
And it's that which the lease back from the investor to the SPV presumably is the instrument under which rent is paid,
Lord, yes.
equivalent to 10k a year. So it sounds like quite a valuable arrangement to be able to sell on.
Well, Lord, yes. And the benefit is of two things. One, it's the rental income which that lease back generates, and that is what it is. So, for example, £10,000 a year. But also there's the underlying asset in the sublease itself.
There's the sublease plus also the lease back. It's the lease back which sounds like it's the valuable asset.
Lord, yes.
Sorry.
My Lord, I've been referred to page 158 of the supplemental bundle. It's our paragraph 58.
Thank you.
And it's subparagraph 4.
I'm so sorry. Could you give me the page again?
It's page 158.
Sorry, big pardon.
My Lord, Lord, I've been reminded that we have the transcript, the transcriber.
Yes.
For myself, I think I plan to be another 35 minutes. I'm content to go until 35 minutes, but your Lordships may wish to take a break now for the transcriber.
We don't usually take transcribers breaks in this court, and normally transcribers arrange for there to be a team of people. I don't know what the position is here.
Well, I'm afraid I don't know. I certainly for myself am happy to press on.
Well, I would press on.
Lord, yes.
For the moment. Yes, thank you.
So, my Lords, as I say, what I wish to do is demonstrate two things. First of all, that the judge's reliance on Saddington was misplaced. And secondly, the judge should have focused on Manchester, which the judge did mention, but didn't apply the appropriate test. Your Lordships may be familiar with the facts of Saddington. We summarise it in our skeleton argument at page 52. And it's paragraph 20. Mr. and Mrs. Saddington owned a house. In 1989, Mr. Saddington sought a loan to be charged on the house. The defendant valuer was instructed to value the property and valued the property at £350,000. In reliance on that valuation, a mortgage was executed on the property for the sum of £175,000. Of that, £75,000 was used to discharge the existing mortgage, with the remaining £100,000 being used by Mr. Saddington for his business. In due course, that business failed. Mrs. Saddington then sued the valuer, alleging that it negligently overvalued the property. In terms of loss, she claimed that as a result of the negligent valuation, she had been subjected to a liability for £100,000, which might mature into financial loss. The valuer applied to strike out, and on appeal, the claim was struck out. And your Lordships will see at 21 over the page, we set out from Lord Justice Balcombe the two key paragraphs of that case.
Yep.
Lords, that case was clearly right on its facts. It was, we would submit, an ambitious case on any basis. But that case is a million miles away from the present case. It's simply not comparable. Well, Lords, in Saddington, the valuer had no knowledge of what the Saddingtons were going to do with the money, nor was there any reason why he should. He was instructed to give a valuation of a property, full stop. My Lords, I'll be coming on to the Manchester case shortly, but to use the language of the majority in that case, the purpose of his duty, of the valuer's duty in Saddington, was very simply to provide a valuation so that a decision could be made whether or not to take out a mortgage. The purpose was nothing to do with how the money raised on any mortgage would be spent. Now, my Lords, by contrast to here, Lupton Fawcett knew full well how the monies were going to be spent. They knew full well that after whatever came out off the top in terms of sale commissions and legal fees, they knew precisely how it would be spent because they had prepared the paperwork or had thoroughly reviewed it, and they knew exactly how the scheme was supposed to work. My Lords, as to what the judge said, if we refer to the judgment, if we could start at page 80 within the court bundle. We see in the middle of the page the subheading causal nexus. In 66, Lupton Fawcett contends that the claim should be struck out summarily because the pleaded losses fall outside of any scope of duty owed by them. It was not sufficient for the claimant to say that but for the negligence, all the consequences that ensued would have happened, and that LS should not be liable. Mr. Saul reminds the court the claimants do not allege fraud. And then reference is made correctly to paragraph 6 of Manchester, and emphasis was rightly made to the second and fifth questions. I'll come back to those. 69, LF contends that the firm was instructed to advise as to whether the schemes were FSMA compliant, and that was the scope of their duties. The firm's duties did not extend to them underwriting the success of the business proposition as a whole. LF was not responsible for how the claimant spent the monies. LF contends that the claimants cannot explain how the monies were lost in a way which is properly linked to breaches by LF of the firm's duties to advise on CIS and FSMA issues. The fact that the schemes were not FSMA compliant did not lead to those losses. Those losses appear to have resulted from what LF describes as Mr. Woodhouse's fraud. In the 70s, the claimants rely on Manchester Building Society case made the opposite contention. They argued that the losses they have suffered were precisely within the risk of harm, for which Lupton Fawcett owed a duty of care. So it's right to say that both sides of the courtroom relied on Manchester. Well, Lord, at page 88, we have the judge's conclusion on this point. And it starts at 112. After reference to Stanford. Here, however, the consequential losses arose from the way in which the monies were subsequently used by the claimants. But the duty of care pleaded by the claimants does not extend to advising as to the way in which the investment or loan monies would or could be used by the claimants. Applying the language of Lord Justice,
including
not restricted to misuse by Mr. Woodhouse.
Yes.
My Lord, yes. And we've accepted, and that's in the pleading, that we'd give credit. I think there's £2.7 million of misappropriations. 113.
Wouldn't misuse include the Ponzi scheme itself?
My Lord, to the extent that that's caused loss, my Lord, yes. And Lord, on that point, I think it's one of the asset co and Grant Thornton case. And if there is prima facie loss, that some of the loss can be attributed to something else, for example, a Ponzi scheme, then there can be a disallowance or deduction referable to that. So, my Lords, in this case, we accept that £2.7 million of the losses were due to misappropriation, and we accept that possibly there could be further deductions for the Ponzi scheme. That's an absolutely theoretical point which we accept. And my Lord, what we'd expect to do, if this were to go to trial, the defendants would put in a defence, and no doubt they would raise that, we'll put in a reply, and that would be a matter for quantification as to what extent of the losses should be disallowed because they should be attributed to the Ponzi scheme. We suspect it wouldn't be a particularly large sum, but that's not a matter for now. 113, the judge said, applying the language of Lord Justice Balcom and Saddington, if there had been a breach of duty by LF in failing to advise that the schemes of CIS, this did not cause the loss of the investment or loan monies. At most, it gave the opportunity for that loss to occur, recoverable. And then finally, 114, the same conclusion is reached if one looks at the scope of duty in accordance with the approach described by the majority of the Supreme Court in Manchester. The duty of care imposed on LF concerned the impact of FSMA if the schemes about which LF was advising and seeking advice from counsel about the CIS. If there was a breach of duty by LF, the only harm arising for which there was a sufficient nexus to the duty of care was the requirement to make restitution to the investors or repayment to the lenders. The requirement is, as already explained, set off in full by the amount received in investment monies or received in loan monies. Accordingly, no loss is attributable to the duty of care which is alleged to be breached.
We're only concerned with restitution to the investors, aren't we? We're not concerned on this appeal with repayment to lenders.
My Lord, yes. So we say the judge was wrong with respect in two ways, at least two ways. The first was to equate the present case to Saddington, and the second was not to properly apply Manchester. As for Saddington, we summarise the position in our skeleton argument. It's at page 59, paragraph 41. And we say in paragraph 41, in terms of the judge's judgment, with respect, this misses the point. It is true the claimants do not seek to blame D2 for the extent to which the investment money was misappropriated. That cannot be foreseeable, but as stated above, there's likely to be a relatively small amount. What the claimants do say is entirely foreseeable, D2 prepared the paperwork, that the investment monies would be used in relation to the scheme in a way which, over the short term, would not give a pound-for-pound return, So that in the event of the schemes being unauthorised, CIS, which they were, it would mean that the claimants have an immediate liability to repay and pay compensation, but are immediately worse off. With respect, the judge appears to have misunderstood that point. My Lord, in short, what we say, the argument is this. In Saddington, the valuer was asked to provide a valuation. And in Manchester terms, the purpose was to enable a decision to be made as to whether a mortgage should be granted. The valuer had no knowledge of, and the purpose wasn't of his advice in valuing, nothing to do with how the money would be spent subsequently. Here it's completely different. Lupton Fawcett were not simply asked to advise in isolation, is this CIS or not? They were asked to advise about the commercial implications as well. That's pleaded.
I thought you told Mr. Justice Sheldon that that simply meant the impact of Section 26.
My Lord, yes.
Yes.
The implications in the context of FISMA. So, in other words, if there was a real risk that the schemes were CIS and therefore not compliant, there was therefore a risk of Section 26 liabilities, and therefore advice should have been given to not take any further investor monies. The implications of Section 26 are severe. They also contain civil penalties and criminal sanctions. And for the SPVs, they create these liabilities under Section 26 2A and B. And
Yes, but that does not. What we're talking about here is the scope of a duty.
well, yes,
It goes back to Samco. And indeed, it's noticeable that Saddington, I think, is before Samco.
it is.
So it's not, I think, surprising that, or Justice Balcom, is it,
Yes.
expresses it in views of foreseeability, which was then the main control mechanism on recoverability of damages for negligence. But he does also say it wasn't the overvaluation which caused the loss of the 100,000 which went into Mr. Saddington's business. That was Mr. Saddington's business.
Yes.
The overvaluation didn't cause it. No, it obviously causes it in a but-for sense, because if it hadn't been for the valuation, the loan wouldn't have been taken, it wouldn't have gone into the business. So he means something more than but-for sense. And what he means is what Lord Hoffman later explained with his characteristic lucidity in Samco, is just because you give advice and someone acts on it does not make you responsible for all the things that are done by acting on that advice.
Well, yes.
So at the moment, I don't see what the relevant distinction is between Mrs. Saddington agreeing to take a loan of 175,000, of which 100,000 goes into her husband's business and is then lost, and the companies, who are the claimants, agreeing to take in 68 million of investments, and then that all going into the schemes where it's all lost. What's the difference? It's not a question of foreseeability. It's a question of what was the scope of the duty of care that Lupton Fawcett owed, and the scope of a duty of care was to advise that there was a potential Section 26 liability. It wasn't what happens to the money once it's received. Have I misunderstood it?
My Lord, only in the last part of what your Lordship has just said. I should say that the Saddington decision was clearly the right decision.
Yes.
And today, the same decision would be reached by reference to Manchester principles. As one can readily see, if one looks at the purpose of the valuer's retainer, it was very specific, and it certainly could not extend to anything to do. The harm was nothing to do with how the money would be spent. That's very different to the current situation in the present case, where Lupton Fawcett were very familiar with the nature of the schemes, and they knew how the monies were going to be spent, i.e. they'd be invested in illiquid assets, there'd be certain leases granted. They knew precisely what the investors would be getting. They knew precisely how the monies were going to be spent. Which is
That wasn't what they were advising about. They weren't advising, are there risks for the companies in putting monies into illiquid assets and so on and so forth. What they were asked to advise about is this a CIS? If so, what are the consequences? And you say that means Section 26 liability. That has nothing to do with what the risk to the company is of putting money into schemes which won't show a profit for a number of years. They're just not asked about that at all, are they?
Well, with respect, they are. We plead that in terms of the commercial implications. But perhaps I can take the court. I need to take the court, if I may, to APOC 5 with how we.
Yep. Yes. Do.
But also, I'd like to take a look to Manchester some key paragraphs which assist. But I suspect it's more useful if I go to APOC 5 first of all.
Yep.
My lord, I think we need to go back. It starts at, I think it's 135.
This is the
In the supplemental bundle. Yes.
Supplemental bundle 1.
Yes. And the document starts at 135. Page apologies. I'm just working through my notes as to the paragraphs relevant to this particular exercise. Well, it is indeed 165. We can see duty and references made under express retained to lead companies. 85A, so this is in red, it was before the judge at first instance. Further, it was an express, alternatively implied term of the above retainers that LF was under a duty to advise of matters reasonably incidental to express duties set out at paragraphs 83 and 84 above. Namely the regulatory, legal and commercial implications arising from the issue of whether or not the schemes were CIS.
Yes. Now I understand that includes the commercial consequences of the scheme being found to be a CIS.
Well, yes.
And if the facts have been that the FCA concluded it was a CIS and intervened, and that was what caused the schemes to collapse, then you would have a claim for saying, well, they should have told us that this was a risk, that the FCA might intervene, and those would be the consequences. But that's not what caused the scheme to collapse. The fact it was a CIS was completely irrelevant to the collapse of the schemes. The schemes collapsed because they could not sustain themselves, because they were never going to make a profit, partly because Mr. Woodhouse was helping himself to money, and partly because the whole business model seems to have been grossly over-optimistic, if not fraudulent. But that's the problem. It's Lord Hoffman's mountaineer's knee. when the mountaineer goes to the doctor and says, "Is my knee fit to climb the mountain?" and the doctor negligently says yes, and he climbs the mountain and falls off and kills himself, that's got nothing to do with his knee. And you can test that by saying, suppose the doctor was right and his knee was perfectly fit. He would still have climbed the mountain. He still would have fallen off and killed himself. Translating that to this case seems to me, you ask Lupton Fawcett, is this a CIS? And Lupton Fawcett say, negligently on your case, no, it's not. So they go ahead with the schemes and they fall off the cliff and everybody loses their money. That's not because it was a CIS. And it would have been exactly the same if Lupton Fawcett had been absolutely right and it wasn't a CIS. They still would have gone ahead and everybody still would have lost their money in exactly the same way.
Well,
So what is it that you've pleaded, the regulatory, legal and commercial implications arising from the issue of whether or not the schemes were CISs, which, as I say, I understood you to tell Mr. Sheldon meant the liability under Section 26. But nobody pulled the plug under Section 26. None of the investors came forward and said, I want my money back because this is a CIS. The FCA didn't collapse the scheme because it was a CIS. The scheme collapsed, as I said, because it wasn't a viable scheme.
well, if I can,
I'm sorry, I've gone on a bit, but this seems to me to be absolutely crucial to this ground of appeal.
well, yes.
And at the moment, I think the judge was absolutely right. So I think you have a bit of persuading to do in the last 12 minutes. Certainly, as far as I'm concerned, as to why this is not absolutely on all fours with the mountaineer's knee.
Well, one can use the mountaineer's knee analogy. It's something which we actually adopt. If Lupton Fawcett's advice had been correct, and it transpires that the schemes were not CIS, and one can, in that situation, there'd have been no FCA intervention at all. Yes, one can assume the claims, the schemes would have collapsed in any event because they were financially unrealistic after X years, as they did. And your lordships will see it was roughly 2019, so several years in, they did collapse. But the outcome for the investors is not the same. Because the actual position is that the investors, now creditors, are entitled under Section 26(2)(a) to their money back, plus compensation. So, yes, we'll give credit, of course, for the misappropriations, and they have to give credit for the monies which were returned, and we accept there may be some credit of disallowance to the extent the Ponzi schemes affected that. But the general position of the actual loss, actually as it is the full amount of the monies, less those things, plus compensation. Under the mountaineer's scenario, under mountaineer's knee scenario, if they had not been CIS, and therefore there's no Section 26 liability, with respect, the Lordship is wrong to say it's the same outcome for the creditors. The creditors would be in a different position. They would have, first of all, their contractual rights. Now, some of them have received, this is 2019, and I think I mentioned it, we certainly pleaded that these schemes were put into administration by then investors who hadn't received their promised returns. But there had been millions of pounds was paid out, it's in the figures. And so many of the creditors, investors now creditors, did receive their contractual obligations to money as they went along. And they would also be entitled to whatever their leases were worth, which may be something or not very much, likely to be not very much as it transpired. So contractually, possibly they were owed monies, but if they were under deferred consideration, they weren't owed that money, or they had been paid it. So there might be some sums they were owed in terms of the rental income, plus contractually they're entitled to their leases subject to the lease back. Relatively limited. My learned friends in their written submissions say, well, there would be surefire claims for deceit. Well, that's a jump. There may have been claims, we don't know. Some of the investors, it will depend on each particular investment, what they were told, what representations were made to them, to what extent was reliant, some would have gone ahead anyway. There are lots of different questions, and it's absolutely wrong, we would respectfully submit, to suggest that had these schemes been CIS compliant, the Mountaineer's Knee scenario, the claims would be anything quite as high. We know they are legal side limitation, 68 million plus compensation, less the various deductions I've mentioned. We simply don't know what the position would be. It would be their contractual entitlement, Mountaineer's Knee, which may not be very much. Potentially, except potentially some claims, but it's pure speculation. And my lord, I do respectfully remind the court, this is not an appeal from a trial. This is on a summary judgment. The way we would have expected this to play out, as we served our articles of claim, the defendants would no doubt raise these points and say, well, the actual loss isn't what we say for this reason or that reason. And in due course, there'd be no doubt expert evidence and further consideration as to what each investors would or wouldn't have done. But we say it's absolutely wrong with respect to say that under the Mountaineers scenario, the alternative, it would have been anything close to the actual sums which we believe to have been lost.
Thank you, that's very clear.
My lord, if I can turn my back to I do wish, if I may, to turn to Manchester, some of the key paragraphs, because this is, I appreciate your lordship will of course be familiar with the case. And we find it at page, in Authorities Bundle 196. And just by way of overview, one can see at 196 there were in fact 7 justices, exceptionally. And to summarise the judgments, all 7 allowed the appeal, but for slightly different reasons, as set out in 3 different judgments. First, there's what people often describe as the majority, and that's set out in the judgment of Lord Hodge and Lord Sales. Between Lord Reed, Lord Kitchener and Lady Black agreed, so that's a majority of 5. Lord Leggett also gave a very comprehensive judgment with which the majority largely agreed, albeit not on all aspects. And then finally, there's Lord Burrows, who also allowed the appeal. Again, a lot of common ground with the majority, albeit some differences too. My lord, the majority's judgment starts at page 202. Sorry, that's not correct.
It is 202 is the bundle.
My lord, yes.
789 is
yes,
the
it is
report.
202. And in paragraph 4, we have a summary of what the majority find. In summary, our view is that 1, the scope of duty question should be located within a general conceptual framework of the law of the tort of negligence. 2, the scope of the duty of care assumed by a professional advisor is governed by the purpose of the duty, judged on an objective basis by reference to the purpose to which the advice is being given. In this context, we use the expression purpose of the duty. And 3, in line with the judgment of Lord Sumption in Hughes Holland, the distinction between advice in cases and information cases drawn by Lord Hoffman in his speech in Samco should not be treated as a rigid straitjacket. And following on from this, the counterfactual analysis of the kind proposed by Lord Hoffman in Samco, that's the Mountaineer's Knee, should be regarded only as a tool to cross-check the results given pursuant to analysis of the purpose of the duty at 2, but one which is subordinate to analysis and which should not supplant or subsume it. They then go on to say, in our view, the scope of the duty principle can more readily be understood without placing the emphasis which Lord Legate does on causation and the counterfactual test. The focus on causation, which gives rise to debate, discussed in News Holland. And paragraph 6 is probably the most cited paragraph. And when a claimant seeks damages from a defendant in the tort of negligence, a series of questions arise. And for present purposes, everyone agrees that it's 2 and 5 which are relevant here. What are the risks of harm to the claimant against which the law imposes on the defendant a duty to take care? And 5, is there a sufficient nexus between a particular element of the harm for which the claimant seeks damages and the subject matter of the defendant's duty of care as analysed at stage 2? So, in other words, in 6.2, the duty of care is to protect against what risks? And is there a sufficient nexus on the subject matter of that duty, whatever it's there to protect, on the other hand, a particular loss or harm? Lord, paragraph 8, the first part is important. The second question, so that's 6.2, addresses the scope of a defendant's duty and is a central question in this appeal. The fact that the defendant owes the claimant a duty to take reasonable care in carrying out the defendant's activities does not mean the duty extends to every kind of harm which might be suffered by the claimant result of that breach. Paragraph 9 is a discussion of Samco. Lord 13, we say this is particularly germane to this appeal. Under the heading, the scope of the duty of care in professional advice cases. In our respectful opinion, the scope of duty question can and should be approached in a more straightforward way than is suggested by Lord Legate. In our view, the scope of the duty of care assumed by a professional advisor is governed by the purpose of the duty, judged on an objective basis by reference to the reason why the advice is being given, the second position, including in the present case paid for. And he goes on to explain how Lord Hoffman was explicit about this in the Samco case. My Lord, there are then various examples in the case law, and given the time, I'll then skip to paragraph 17, and we have reference to the Mountaineer's Knee example. From paragraph 18, there's a discussion on the advice and information cases, and the conclusion, in short, that is probably less than satisfactory, and it's simply to focus on purpose. In paragraph 23, there is an application of the Samco style counterfactual. And at the foot of 23, about 5 lines up, in that regard, we agree with Lord Burrows that the counterfactual test may be regarded as a useful cross-check in most cases, but it should not be regarded as replacing the decision that needs to be made as to the scope of the duty of care. Lord, then have what's actually, we say, instructive is we then move on to the facts of this particular case, of Manchester itself. In 26, another problem associated with counterfactual analysis of this kind is the danger of manipulation in argument of the parameters of the counterfactual world. Lord Legate points out that the counterfactual test can yield the right result if it's properly applied. However, the more one moves from the comparatively straightforward type of situation in the valuer cases, as illustrated in Samco, the greater scope there may be for abstruse and highly debatable arguments to be deployed about how the counterfactual world should be conceived. One has to take care, therefore, not to allow the counterfactual analysis to drive the outcome in a case. To do so would create a risk of litigation by way of contest between elaborately constructed worlds advanced by each side, which would become increasingly untethered from reality the further one moves to the relatively simple value of case addressed in Samco. There is an element of this in the present appeal, as Mr. Salcedo, Queen's Counsel for Grant Thornton, sought to persuade us that the counterfactual world in this case should be constructed in such a way to show that Manchester would have suffered the same loss if Grant Thornton's advice had been correct, and society responded in kind with elaborations of its own. And then at the foot of paragraph 26, just after the words in brackets, 5 or 6 lines up, the fact is that a distinguished constitution of the Court of Appeal, I'll go further up. Lord Legate engages in sophisticated analysis to answer the elaborate variants of the submissions of article parties. The facts of the distinguished constitution of the Court of Appeal fell into error because of them. Again, it seems to us the better approach is to focus more directly on the purpose for which the defendant gave the advice in question. There is no need to apply a counterfactual test to arrive at the correct conclusion, and it has the potential to confuse rather than assist the correct analysis.
Mr. Pickering, I think we can probably read Manchester for ourselves. How do you say it applies in this case, and why did the judge go wrong?
Well, the key point in Manchester is under 6.2, one has to look at what are the risks of harm
Yes.
which the claimant, which the law imposes on the.
What do you say the risks of harm are here that LF was instructed to advise
Well,
against?
we say the scope of duty undertaken by Lupton Fawcett in relation to the claimants included guarding against the risk of harm, was guard against the risk of promoting and operating unauthorised CIS,
With what consequence?
which would, if it was discovered in due course not to be CIS, to give rise to immediate and foreseeable losses in relation to each scheme. And your lordships, I'd invite your lordships to actually consider the facts of Manchester itself.
No. Let's leave Manchester on one side. How do you apply the principles of Manchester to this case? Because what the judge said, 114, was the harm arising for which there was a sufficient nexus to the duty of care was the requirement to make restitution to the investors. Do you dispute that?
My lord, yes. What we say that the purpose of the duty, Lupton Fawcett had a retainer. It was instructed to advise on the CIS point and the implications, including the commercial implications. One has to ask the question: what was the purpose of that advice? The purpose of the advice. What was the harm? The risk of harm which it was to guard against. The risk of harm was the implications if the schemes transpired to be CIS, and the commercial.
And those were that you'd have to pay money back to the investors. That was the Section 26 liability. That's the harm which they were guarding against.
Well, yes.
But what other harm are they guarding against? They're not guarding against the harm that Mr. Woodhouse would go and steal the money. They're not guarding against the harm that the schemes would collapse because they weren't sustainable. They're guarding against the risk that the schemes were not authorised and therefore Section 26 liability would kick in.
Well, yes, we agree with those things. In terms of the risks of misappropriation, of course not. That was nothing to do with Lupton Fawcett. In terms of to the extent it was a Ponzi scheme, whatever losses, whatever there'd be, rather difficult to analyse. Again, we don't try to suggest that was down to Lupton Fawcett, but Lupton Fawcett was specifically instructed to advise on whether the schemes were CIS and the commercial implications.
Yeah, sorry to interrupt. The expression commercial implications appears repeatedly in the pleading.
Well, yes.
I was looking to see if that was defined somewhere, because it's a nebulous expression. On one view, if they knew all about the Ponzi scheme, you would say perhaps it covers that. But what does the pleading mean by commercial implications?
What it means by
does it say?
Well, no.
No, that's what I thought.
Well, no. It would have done in APOC 6, but it doesn't in APOC 5. But what Again, my lords, I emphasise this is
You're saying that because the same expression is used in your skeleton. Commercial implications include the fact that there weren't going to be internal to the SPV many returns in the early years,
Lord, yes.
and therefore at that stage there'd be a risk of collapse,
Lord, yes. If this was a scheme which is going to be profitable from
and
high
therefore a
profitable
risk
from,
of Section 26 claims.
Lord, yes. If this was a scheme which was going to be highly profitable from the start, the Section 26 implications would be relatively limited.
This seems to be setting up a parallel cause of collapse as opposed to a cause of collapse which is known, namely the Ponzi scheme.
Well, but at any particular stage in the early parts of the scheme, the investor's contractual entitlement was highly likely to be less valuable than the return of their money.
Raise this question. Say that the solicitors had an obligation to advise correctly on CIS and advise on the implications in law if it was a CIS.
Well,
That would carry with it the risk of Section 26.
well, yes.
But unless it's clearly pleaded, why would the solicitors be obliged to advise on the obvious? That then that claims to recoup investment if the scheme should collapse for whatever reason, whether it be Ponzi or because it was a rather silly investment.
Well, Lord, the implications of Section 26, i.e., if Section 26 didn't apply, the investors would at any particular time be entitled to whatever their investment was worth under terms of contract. If Section 26 did apply, the investors would be entitled to the full amount back as compensation. In circumstances where it was known that in the early years of the scheme, that Section 26 liability was likely to be greater, substantially greater than the contractual entitlement, and they wouldn't have enough money. In those circumstances, the commercial implications were, if it's a serious risk, you should not be taking investors' monies. Well, that's the point, and that's why this is wholly different from Saddington. In purpose terms, in Manchester terms, the purpose of Saddington is very simply to advise on the valuation, and the valuer clearly had no idea, why would he, as to how the monies were going to be spent. The purpose was to enable a decision to be made as to whether a mortgage should or not be granted and taken. Here, in terms of the retainer, as we pleaded, even under APOC 5, is to advise not just whether these schemes were or were not CIS, but the commercial implications of the same. The commercial implications were that if these schemes were CIS, contrary to their advice, there would be a liability which would bite, which would be for the full sum plus compensation, which would be far, far in excess of the contractual sums due. And LF knew that. They knew the schemes because they drafted some of them and they had advised on all of them. So if one then asks in Manchester terms, what is the purpose of Lupton Fawcett being advised? What were they seeking to advise against? It was the risk of these schemes being CIS. Just as in the Manchester case itself, Grant Thornton were instructed to advise as to whether or not a particular accounting process could or could not be applied. And a first instance on appeal, it was held that the costs of breaking out of the swaps wasn't recoverable. And I invite the courts to actually consider the particular decision in Manchester itself and the scope there, and how the court respectfully disagreed. It accepted most of the factual conclusions of the first instance judgment on appeal, but didn't accept the overall conclusion as to how it affected. Now, I appreciate I've run out of time, but I would invite the court to consider the facts of Manchester itself. Here, my lords, the implications, the purpose of the duty was to protect against the risk of these schemes not being being CIS. And the implications, as I say, affect the whole of the monies, less the various deductions to which we've referred.
Okay.
Lord, the final point I say, which will take literally 30 seconds, is to repeat once again, this is in relation to a strikeout application, in relation to which there hasn't even been a defence.
Yes. Thank you very much. Anything else?
My lords, unless I can assist further.
No, thank you very much, Mr. Pickering. Yes, Mr. Searle.
My lords, this is an attempt to reverse engineer a liability on the part of solicitors for alleged losses which they had no role in causing and no duty of care in respect of. These solicitors, my lords, are alleged to have provided regulatory advice on the application of Section 235 of FISMA to the schemes in question, whether they were or were not CIS. What the claimants seek to hold them responsible for on analysis, and I will take you through this with, I hope, care, are the financial consequences of a massive Ponzi fraud, which they had no involvement with, are not alleged to have had any involvement with, and are not alleged to have had any duty to guard against or reason to suspect. And it is completely extrinsic to the alleged breaches of FISMA. Put differently, and using the language of MBS, the losses which these claimants claim to have suffered do not represent the fruition of the risk which it is said that my clients owe duties to protect. And it's my Lord, or Justice Holgate's point, instead the claimants seek to put up a non-existent factual scenario whereby these schemes might have failed at an early stage for non-fraudulent purposes. And they say, well, in that situation, Lupton Fawcett knew that was a possibility and they are liable. But that is simply not what happened here. The judge understood this very clearly. His analysis is unimpeachable with respect. And I appreciate fully that when my lords have exchanges with counsel, they are simply testing the argument. They are exploring. But my lords, the instincts that my lords, I hesitate to suggest, have expressed in those exchanges are absolutely sound, if I may respectfully say so. And that my lords have squarely captured the fundamental analytical problems with this case, which make it absolutely amenable to striking. There is no reason why this case shouldn't proceed. And my lords, the start and the end of the appeal, as I will show you, the start and the end is the claimant's own case stated repeatedly that the reason why the schemes collapsed and why they are insolvent is because of Mr. Woodhouse's fraud. And I will get into, my lords, the analytical points, the question of the unenforceability under FISMA being one-sided. But you have already identified, my lords, and it's apparent in the appeal replacement skeleton that we've looked at today with my learned friend, that grounds 1 and 2, we're just first on ground 1 and ground 2 at the end, both are entirely dependent, in terms in the skeleton, on this suggestion that the liabilities under FISMA are immediately arising. It is simply wrong as a matter of law. I may not need to take a great deal of time over it, we've looked at FISMA. But there is a requirement to elect. That is just one point that is a fundamental obstacle here. And my lords, in my submission, one can tell a case that is analytically flawed, because no matter how you try to pitch it, no matter where you might turn, you run into another insuperable problem, another brick wall. And there's nothing the lawyers can do about it. No matter how midnight oil is burnt on this, no matter how many epochs we are treated to, the different expression of the case just runs into another problem. And that's why we've had so many attempts to formulate a coherent case, both prior to the hearing between Mr. Justice Sheldon and since. But no matter how one might turn, no matter how much one might seek to elide things, the claim is fundamentally flawed. And one can, and my Lord Justice Nugee, in exchanges with my learned friend when discussing Saddington's, noted that in that case, the problems with causation were expressed in terms of foreseeability. It may have been Saddington's or Galoo, there's reference to fair, just and reasonable, back to Kapara and Dickman. But when one expresses it in terms of the old-fashioned doctrines, or the more recent formulations which now find favour, including in MBS, the new expression of duty nexus, which Lord Leckett preferred not to use, but the majority did adopt. One can use different forms of expression. In some of the cases, this might have been portrayed as a novus actus case, for example, with the fraud. But no matter how one characterises it legally, the outcome is the same. And as is often the case with cases of this nature, there are a number of ways you can approach it to demonstrate and expose the flaw. But whichever way you start, you always end up at the same outcome. And the conclusion of my submission is clear, whichever analytical route is preferred. And there are quite a few different options. Just for example, that point about there being no immediate liability to investors under Section 26 when the investment is made, that on its own would be enough to dispose of grounds 1 and 2. But actually, one can also approach it from the low loss perspective, one can approach it from the scope of duty perspective. There are different approaches, all roads lead to Rome. My lords, and structure from this point forwards, I propose first to address you on what I would describe as some of the fundamental conceptual difficulties of the claim, including relevance to the case law. I then propose to address you, and in doing so, I should say, I will be addressing you both on no loss and scope of duty in parallel. Because as the judge observed in his judgment, they are two sides of the same coin to a significant extent. It's actually how the judge was here maybe a little bit unkind to me in his explanation in the judgment. He suggested I put these points totally separately, and that wasn't how I'd remembered it. So I went back to the transcript and checked. I'd put them one after the other, naturally. One has to deal with one after the other, typically. But we've always seen scope of duty and no loss as two parts of the same coin, because the point is, what we have done has not given rise to a loss. What we were responsible for has not given rise to loss. Insofar as there has been a loss, we don't accept. If there has been, it's nothing to do with us. So that will be the main part of my submissions will be the fundamental conceptual difficulty. And I'll explain in a moment exactly how I'll break that down. Once I've done that, I will then address you on what are effectively the heads of loss now advanced, which one sees identified in the replacement skeleton. Some of those run into very significant pleading points because we are working from the document that was before Mr. Justice Sheldon, and they seek to recast their case very significantly. But in any case, the points suffer from the analytical flaws regardless. And at the end of that process, the last limb, the last element will be this attempt to introduce now on appeal the claim for Section 26(2)(b) compensation, capital C, for our purposes, not in the Act. And a couple of key points to mention there. It wasn't pleaded. It's still not pleaded. I've shown you the total of the losses in the pleading and how those losses were broken down in the schedule to the pleading. There was and is, and I emphasise, and is, no claim for Section 26(2)(b) compensation. The question then is, well, was the judge entitled to approach the matter on the basis that it wasn't pleaded and that the attempt to introduce it by way of oral submissions in response was not acceptable when you've had the argument in front of you, at least in correspondence for almost a year, then witness statements, and so on? Points we debated earlier this morning in relation to the introduction of the yet further plea. And the point I'm making is that this was a decision of case management by the judge. He's entitled to adopt that approach. They've had a year since we've intimated the claim. There's been much made today of, we introduced the first particulars of claim under time pressure. Whether or not that was so is immaterial. I don't seek to hold anyone to the pleading from August 2022. We're talking about the pleading from January 2024, by which point they've had almost a year's notice of our fundamental analytical flaw arguments, and they are fully funded. And the judge was more than entitled to adopt the approach he did. They seek to suggest that there was some manifest error, but he's more than entitled to do that, unless they can demonstrate some failure to exercise his discretion in a manner so severe as to give rise to irrationality or the like, then they can't get past this point. And there was certainly no error of law, not suggested there was an error of law. So the judge is faced with a case management decision about whether to allow these new points to be raised by my learned friend on his feet when they've had so much notice. And he said no. And so that's hopeless for that reason as well. It also failed to claim for compensation for similar analytical reasons to outcomes. Because the key question, my lords, the key question that transcends all of this is, why do these claimants not have the money to pay the amounts they say investors need? It's not sufficient for them to say, I have a liability. They've got to pin on us the fact that they no longer have the money. Their pleaded case, these claimants, and I will show this to you, is that, and I quote, they have lost the entirety of the investor receipts, close quotes. That is their pleaded case. That is absolutely nothing to do with us. And it is not even alleged to be. Because as Mr. Justice Sheldon observed, paragraph 112 of his judgment, it is not even alleged, and it's still not alleged, that we owe any duties to advise on how the monies received could be used. Not alleged, not arguable, which is why it's not alleged. I mean, it's not a criticism of the claims, they're quite right not to allege it, it would be unsustainable. It would be completely contrary to all of the well-established case law on the limits of solicitors' duties. And that recognition at paragraph 112, there's no such allegation, was shown to you by my own friend as he went through the judgment, and there is no derogation from that today, and rightly so. It's the same view. So, my lords, that's the position in overview. During my submissions, like my learned friend, I expect to take you to my skeleton at some points where it pulls together some of the references in a compendious way. And before I now launch into the meat of this, may I just add two prefaces, just really for completeness. Now, naturally, given the nature of this appeal, we are arguing it on the basis of hypotheticals as to whether or not there is a breach of duty and whether but-for causation is satisfied. But of course, and I just say this for completeness, my clients reject any such suggestion. You will see that we repeatedly consulted counsel, on the CIS question, we did relay the advice given in the way described in the pleading, and we certainly also fiercely reject the suggestion that the but-for test is satisfied, and I developed that below, and the judge said it was a very strong case, or words to that effect. The claimants may struggle to establish their case at trial on this, but they got over the line on the factual causation point. But it's striking, as my Lord Justice Nugee observed, that the advice from Mr. Green was passed on and Mr. Woodhouse carries on. But I recognise that we are proceeding here on a hypothetical basis. The last preface is this: there was reference to these qualia schemes. My Lord, this case is not about the qualia schemes. They involve different participants, different companies. My clients have never fully denied any liability, and the claim was settled with no admission as to liability at all. So nothing turns on that at all.
But it doesn't matter, because for the purposes of today, we assume the claimants might be right, that this was in fact a CIS scheme, and that you should have told them. You should have told them there was a risk. We're not in a position to, or interested in, whether it is in fact a CIS scheme.
So we are focused on the analytical flaws that flow after that in the discussion. My Lord, section 1 then, this is the main meat of my submission. That's always an advocate's promise, and then it turns out that I'm much longer on my other points as well. But this should be where the core of the debate takes place. I wasn't intending, by the way, in this section to deal with the FISMA specific points about immediate liability to repay. That may come later. That doesn't mean that it's of any less significance. So I just mark that point and park it for now. Now, I propose to address you in the following broad structure within this main section. First of all, I will look at what is and what is not alleged by the claimants themselves, so far as concerns 1, the causes of their financial predicament, and 2, what my client was or was not responsible for. Because those things, my lords, have to overlap in the Venn diagram in order for liability to attract. Secondly, I will deal with the mountaineer's knee, Samco counterfactual. My learned friend Mr. Pickering is absolutely right when he says that MBS says this does not drive the analysis, it is not the decision, it is a useful cross-check, and their lordships recognise that. And my Lord Justice Nugee's assessment of how that Samco mountaineer's knee counterfactual works in this case is absolutely on point, if I may respectfully say so. The suggestion that we don't know what the loss would be on the other measure is a false submission analytically. And I can tell you why, because we know what the contractual entitlements are. It's the 225%.
Is that in every case?
Sometimes the return is as low as 8% per annum. But you're still going to, but with your buyback, which is pleaded at 125%, you are always going to get to at least 200+% contractual entitlements. Somewhere between 80 and 120% on the annual coupon.
And the buybacks are always 10 years?
The buybacks come at the end of 10 years, and the pleaded case is 125%. So you get your coupon for 10 years at between 8 and 12%.
That's too good a deal.
And then you get your 125% as well at the end.
I mean, that's the problem. It's too good to be true.
We'll see what the claimants say about this. They say that Mr. Woodhouse knows that. So it is a fraud. When my learned friend says, oh, we don't know if it's a fraud, let me show you what they allege of Mr. Woodhouse, what they allege in so far as concerns how these schemes were promoted. There is no gap.
I'm not expecting an answer tonight, but you might like to think about this overnight. Where the schemes collapse and the companies go into liquidation long before the 10-year buyback is reached, would a creditor, assuming it wasn't a CIS and it didn't have a Section 26 claim, be entitled to put in a proof for the contingent right to get 125% in 10 years,
They would be entitled to prove for their contractual entitlements.
even though it's a future and contingent right?
And it may be in some, if one is being
You might have to
abstract in the
discount
analysis,
it.
there might have to be a discounting process in the same way that one sees for personal injury claims, for example, where you reflect the fact that it's a present recovery.
Because in a liquidation, you strike the balance at the date of liquidation.
Yes, it's the collective enforcement or collective execution process that the Chancellor referred to in HSBC and SIB. I appreciate my lord has a greater understanding of these principles than I do, but there may have to be some measure of discounting for net present value. But for present purposes, one is looking at significant contractual returns, even allowing for some measure of discount to reflect receipt at the point of time, and then the buyback. And so your contractual entitlement is always going to be greater, always. And so the Mountaineers' Knee is absolutely squarely satisfied here in my client's favour, because the companies are never going to be worse off in this situation where the schemes where there is negligence. So it's counterfactual. I'm rather giving away the contents of what I'm going to deal with, but it may make it quicker tomorrow. Thirdly, I will address you on the claimant's argument that mere awareness of the likelihood of legitimate expenditure, ex hypothesi legitimate expenditure, by them as part of their business gives rise to liability on our part for that expenditure, as it appears. That appears to be how it's now being expressed.
That's the commissions and the legal fees.
And I will address you also on the suggestion that there's a material difference because whether it pre or post states the transaction. Fourth, I will then carry out, having carried out the analysis of this case, I will look at the authorities, having well in mind my Lord's observation to my learned friend that the court can read judgments for itself. I will try and alight on particular points in particular judgments to show how the law operates as a coherent whole and shuts out this claim. And so, my lords, the work that my clients did not.
If that's where you've got to, is that a convenient moment?
So long as I won't be told off tomorrow for wasting 10 minutes of court time.
I don't think so. I mean, I hadn't appreciated that your timetable had us going till 4:30 because usually in this court we sit till 4:15.
Well, we've certainly exceeded 4:15. I can break now. It's a natural point. I'm in my lord's hands.
Let me just. Yeah, we'll break now. We are quite familiar with the points that you are facing and the points you want to make in general. I think you will have enough time to get through your submissions. You have, as I see it, until 2:30 tomorrow. I think you should try and tailor your submissions to that, but I don't anticipate that will cause you significant problems.
My lords, I have some so I hope it's good news. We have some tabs in court.
Ah, yes. Well, could you hand them in?
There's a logistical question about how you would like, by whom you would like them to be inserted.
Are you offering to do it yourself?
Well, I dare say I've been offered less glamorous tasks in my practice. So
that was a slightly facetious comment.
Well, I know, I'm trying to engage with it, but we can help, or if my lords prefer a different course, you've marked up the bundles. If you wanted an independent lawyer,
I think it's probably fine for you to hand them in, and if we want any further assistance, we will get in touch with the parties
They should hopefully match up to the indices, and we have tabs for the core bundle up to tab 14, for the supplemental bundle I think up to tab 50, and then whatever's left for the authorities on the appeal, which I understand you don't have tabs for either.
No.
Thank you very much.
Well, I'm very grateful, but I won't need any tabs because I'm using the machine, so thank you very much for the thought.
Yes, thank you. We will say 10:30 tomorrow.
All right, able.